Thank you very much, Kathy. And it's great to be back here for our last program of October 2025. Tough to believe that we are already that deep into the year. Although here in at least my household, I know in New York City, we're getting ready for Halloween and trick-or-treating on Friday. And I've got one kid who is dressing up as a gigantic banana, and another in middle school who hasn't yet told me what she wants to do, which is probably about right. We are nonetheless, here to tell you plenty about what it is that's happening in New York State and beyond. There's lots of activity that we want to catch you up on. And if Kathy, go to the next slide, I will walk everybody through that. So I'll be providing not only a moment to talk through this agenda, but also to touch on government and regulatory affairs, which, as always, there's something to say, and so stand by for that. Steph Fedorka is with us from our Rochester office, and she is going to tell us about a leave law expansion. Steph is someone who tracks that all across the state for us and is going to focus on a New York City change, which is quite important, certainly for our clients and friends who operate within New York City, and it'll have ripple effects as many things out of New York City do. Um, Liz Heifetz is with us back again, and we thank Liz for joining us. She is going to provide us with updates on issues around immigration. Obviously, it's been a topic of discussion that we've been covering throughout the year on the webinar in 2025. It has been a fairly active space, of course, and so Liz will provide us with the latest. And then a new member of the bond team, attorney Connor Ingerson, is with us from Syracuse. Connor, I should say, is not new to bond, but new to the webinar specifically, and new to all of you in that regard. He will be walking through a package of housing bills. He sits in our property practice and certainly is well equipped to help you understand the implications of them in the property relating spaces. So, Kathy, why don't I turn now to what it is that's happening in New York City government? Thank you. The and I should say federal government as well as New York State, but in the federal government to begin, the shutdown continues. There are implications around that, which we are starting to see. I just was reading that earlier. Uh, in fact, just yesterday, the governor here in New York, Governor Hochul, is now issuing about $30 million in connection with the SNAP food benefit program that has interconnectedness, not just to the shutdown, but all the more to HR1, which we've talked about here, and some of the changes afoot with regard to the administration of that program. So the shutdown is, certainly something that will remain a topic of discussion for all of us, and that has implications that are local and will keep all of you apprised. In New York State, we know that the fiscal 27 budget is beginning to take shape. Excuse me. I talked about that when I was with all of you 2 weeks ago, and that agencies are developing proposals. It is going to be an austerity footing kind of budget. That is unquestioned. We are also seeing the volume of activity around the governor's decisions with her pen with regard to bills that got through both houses of the legislature in the 2026 session. There have been a number of vetoes, nothing so monumental that suggests that we want to take specific time today to cover it, just making sure all of you appreciate, as is typical this time of year, the pace begins to pick up. And what the governor, by and large, we have noticed a pattern has vetoed are elements that are, requiring of new monies or otherwise that would, lead to processes outside of the standard budget and appropriations processes, all connected up to that picture around austerity that I was alluding to. And then in parallel fashion, all across New York State, we're seeing early voting already underway. Here in New York City, where I'm speaking with you from, we have, among other elections, mayoralty to be decided on November 4th. And, the former Governor Andrew Cuomo is running against Assemblymember Mamdani and as well Curtis Sliwa. And across the state in Buffalo, Albany, and other major municipalities, there are elections that are quite significant. And so we'll be tracking the results of that as we move into November. So that's all for today in terms of my quick updates. And let me quickly turn now to Steph, who's here to tell us about what's happening in the leave law space. What happens in New York City tends to ripple forth across the state. So let us know what's new that you've heard about and otherwise are ready to tell us about. Thanks for being on again.
Thanks, Gabe, for having me on. And that's right. We look to New York City to give us maybe some foreshadowing of what might be to come for the rest of the state. Kathy, next slide, please. So I'm here to talk quickly about a very new update, the New York City Earned Safe and Sick Time Law, which has been in effect for some years now. The City Council passed significant changes to that law. That was officially adopted on Saturday, October 25th. And it becomes effective in 120 days. So February 22nd, 2026, which is on a Sunday, but I think getting us prepared, and I'll have some tips for employers. What does this mean for you if you have employees working in New York City, even if your headquarters is not in New York City, or your other physical mortar places, brick and mortar places are not in New York City. If you have employees working from New York City, this is important for you. Next slide, please. So the key changes, the amendments expanded qualifying reasons for leave and using that paid sick time under the city law. Previously, or I should say currently, right, employees have a right to use paid sick time that they have to be provided by their employers for things like caring for themselves or for a qualifying family member, medical appointments, leave related to domestic violence, sexual offenses and stalking and human trafficking, as well as closure of a place of employment or childcare center due to a public health emergency. So now that we have these additional new qualifying reasons, and I should say, instead of, not now, but as of February 22nd, 2026, these reasons will be covered, and employees are going to be able to use their paid sick time for things like public disasters. That's defined as a fire, explosion, terrorist attack, severe weather condition, or other catastrophe that's declared as a public emergency or disaster by the President of the United States, the Governor of the State of New York, or the Mayor of the City of New York. This may also include direction by a public official to remain indoors or avoid travel during a public disaster that prevents an employee from reporting to their work location. In addition, we have time off for caregiving responsibilities as well now. So employees can use this time to provide care to a minor child or care recipient when the employee is a caregiver for that minor child or care recipient. Leave related to subsistence benefits or housing. So employees now need to be able to use that paid sick time to initiate, attend, or prepare for a legal proceeding or hearing related to subsistence benefits or housing to which the employee or the employee's family member or care recipient is a party. This may also be taken by an employee to take actions necessary to apply for, maintain, or restore subsistence benefits or shelter for the employee or their family member or care recipient. And finally, there were some changes to the safe leave provisions within the paid sick time law that now include victims who are victims of workplace violence. So employees can now use this time for certain reasons, including but not limited to seeking legal or social services, meeting with the district attorney, or filing a complaint with law enforcement related to when the employee or the employee's family member has been a victim of workplace violence. So those are the significant expansions of the qualifying reasons. In addition, the law now requires an additional 32 hours of unpaid sick time that needs to be provided upon hire, front-loaded to all employees, and then annually thereafter, right? And that time is for those qualifying reasons under the paid sick time law as well. And again, this is additional to the 40 or 56 hours that you have to provide of paid time off under the existing Earned Safe and Sick Time Act. Lastly, these amendments make significant changes to the Temporary Schedule Change Act. So previously, employers had to accept up to 2 requests per year of an employee asking for a temporary schedule change under the law. Now, employers are no longer required to accept or approve requests for temporary schedule changes under that act. The act is still in place, it still does exist, but employees still have the right to request a temporary schedule change. The reason being is that some of those reasons, including requesting for subsistence benefits and the caregiving responsibilities, those were qualifying reasons for asking for those temporary schedule changes under the TSCA. Those are now available as qualifying reasons under the paid sick time law. And so employees no longer have the right to those temporary schedule changes, but they still have the right to request them. Employers have to respond to a request as soon as practicable, and employers can propose an alternative temporary schedule change, but the employee does not have to accept that. Notably, retaliation is still prohibited, so employers still need to be mindful of those protected activities under the Temporary Schedule Change Act. Next slide, please. So what does this mean for you as employers if this affects you, if you have employees in New York City, right? Prepare for compliance with these new changes. We mentioned that this takes effect February of 2026, but I think that will come quickly, right? So you're gonna wanna evaluate your PTO or sick time policies as well as your Temporary Schedule Change Act policies and revise them to align with these new changes. Work with legal to understand those changes and update any policies for compliance, but also remember that it's not a one-size-fits-all approach for every workplace, so you can tailor your policies to meet your workplace needs, goals, and objectives. Again, critical to work with legal so that you're striking that right balance and creating something that works for you, but is also compliant with the law. Ensure that you're tracking and reporting accruals each pay period correctly, right? Remember that that is a requirement under the existing and current paid sick time law under New York City, as well as the state law. So make sure that you have any revisions to that system that need to be made or changes. Train supervisors, managers, HR, anyone else who is responsible for attendance enforcement should be updated on these significant changes. And stay tuned for updated legal guidance. I'm sure we'll see something from the New York City Department of Consumer and Worker Protection, which is the local agency responsible for enforcement, including an updated Workers' Bill of Rights, which employers have to provide to all employees, now reflecting these changes as well.
Steph, thank you. That was a very thorough update, and you have a bunch of questions awaiting you in the chat. Clearly, what you had to say is important for lots of folks here to know more about, and so thank you for providing them with a snapshot. And I agree with you, February will sneak up on us. So again, we appreciate you coming on, and please do provide us with updates as implementation becomes more patent. In the meanwhile, I'm going to shift over to our next speaker, who is Liz Heifetz, who is with us from our New York City office in Manhattan, and who has been on the program a number of times already this year to talk about the changing environment around federal immigration policy and the implications for many of you as employers who need to stay abreast of all that is shifting here. So Liz, what's new since you last were on?
Thanks, Gabe. Yes, of course. Good morning, everybody. So I'm here again to talk about what has come up since, September when, the first, main chaotic moment of immigration federal policy has come, alive. So Kathy, can we go to the first slide right away? I'm going to try to do my best to, make this as succinct as possible. Please feel free to reach out if there's questions. A lot of this is going to be a case-by-case basis as it is applicable to you. But as a quick recap, back in September, on the 19th, this proclamation came out that said, okay, all new H-1B petitions must be accompanied by a $100,000 fee by the employer. This sparked chaos. The government issued clarifications. We still didn't really know how this would work in practice. There was a lot of unanswered questions. Time has gone by. We have seen implementation. So I wanted to kind of bring you in on the context and kind of also reassure you so that if you are considering bringing on new H-1B employees, rather, to maybe not fear it as much, because some of this might have different practical implications. So who does this concern? Who is this applicable to? This $100,000 fee is only applicable to new H-1B petitions that are filed for those individuals outside of the US who do not have a current H-1B visa. So from a practical standpoint, right, many employers are not going to be impacted by this in the sense that, you know, for example, higher education institutions and universities, most of them who are bringing in faculty hires already here on an F1 and we're changing status or we're amending or they have an H-1B from another university. None of those will be impacted. It's actually going to be more rare to kind of be in a situation where you would need to pay this fee. Not impossible, but it's just, you know, just to reassure you to know that if there are people out there that you want to bring on that are good candidates, don't be scared to potentially move forward. And you can always reach out to us and ask us questions that we can assess. USCIS will determine kind of if, you know, the person that is changing status or for whom we're extending their stay, if they were in valid status at the time of filing. And if for some reason they say, nope, we decide that they weren't, you know, maintaining status, then we will apply this $100,000 fee. In practice, this is not really going to be the case so much because if someone is already not in status, most likely the attorney working on the application is not going to file a change of status because you have to be in valid non-immigrant status. So in practice, less of an issue we can discuss on a case-by-case basis, but just so you know that this is only applicable, I'll reiterate, for those foreign nationals who are outside of the US. Kathy, can we go to the next slide, please? Okay, so who is not impacted? And, you know, a lot of this might be review, but now we have, you know, confirmation from filed petitions to confirm this. Anyone who's amending a petition, a job description changed, you know, promotion happened, a salary over $10,000, no impact. Another extension, change of status, none of this will be impacted. I kind of mentioned this in the last slide as well. You know, existing H-1B visa holders, obviously a lot of them have come and asked, you know, well, what if we travel? We have an existing H-1B, what do we do? Non-issue. They can continue going and coming as they have always done. This will not be impacted whatsoever. International travel specifically, you know, the only thing I will just reiterate again is for those of you that have, you know, H-1B employees that are traveling internationally, just make sure to remind them that they're carrying their original approval notice, an employment verification letter that is, you know, confirms that they're still employed by you, and 3 most recent pay statements. That's all they need. They've always needed that. They should just definitely make sure to hold that with them because sometimes if they don't have it, you know, they might get questioned at the border. But this is old news. They should just remind them to do so because some of them do forget. And if they have that, they will be fine. And then also, this will not impact consular notified petitions that were filed before September 21st. And, you know, just so you understand what this is, if you haven't dealt with this, is there's usually 2 ways of filing new H-1B petitions. One is a change of status, which essentially says on the date we're requesting you change status, that person will automatically become an H-1B visa holder. For consular notified petitions, we still have a requested, you know, time frame that we're requesting, but that petition is not going to be physically activated until they go to the consulate in their home country to activate it. And because, you know, in some cases, some people have, you know, another year left on their F1 and they don't want to, you know, activate the H yet, but they want the approval. In these cases, it already has, you know, we've seen this at the consulate. It's a non-issue. If your petition has been approved before September 21st and you go activate it, you know, next year, for instance, a non-issue, it will be fine. And also, while on the topic of consuls, I also just want to reiterate that a policy was handed down a few months ago as well. That kind of said, essentially, well, there's going to be a gray area. You know, we'll know more as it comes out. But overall, in the past, some people would, you know, could apply at different consulates in the, you know, at various countries, not necessarily the U.S. consulate in their home country. And that was sometimes a non-issue. There's, you know, third country visa, you know, national visa processing, non-issue. They have stopped that. You can only process in your home country. And I know a lot of foreign nationals have asked me that. And so if anyone asks you, employees ask, you know, that is usually the case. We generally, you know, you don't want to get into the gray area of going elsewhere because they could get denied. There could be a lot of implications. So just kind of throwing that out there as well. Okay, next slide, Kathy. I would be, you know, remiss if I didn't also mention this. I don't know how applicable this will be, but it is possible. I just want to, you know, let you know that if there is somebody that you want to bring on, there could be individuals, depending on their job position, that you really do need. it is possible that you could go through with it without filing the $100,000 fee. If we can make an argument, that it is in the national interest and that no American worker is able to fill the role. There's ways to kind of respond to these, but this is going to be, talk to attorney, reach out to me, let me know. We can discuss if it's a viable case, if it's a route you want to go to. But all you have to kind of just understand right now is there are exceptions. They're limited. There's a high threshold, to meet in order to get approved on these grounds, but it does exist. So just know that there are some exceptions. Okay, moving on. Kathy, please, next slide. Project Firewall. I also mentioned this in, the last webinar and when, this whole H-1B situation exploded last month as well, but we have more information on this just to kind of clarify. So what is Project Firewall? This was the new federal H-1B enforcement initiative that is, intended to protect American workers and ensure there's compliance in the H-1B program. It's kind of unprecedented. So, let's look at it this way. In the past, Congress has always restricted the Department of Labor's ability to open an investigation. The law was always, allowed for the Secretary of Labor to do so. It's a dormant law, and this Project Firewall is essentially activating this old, law that says, you cannot proceed without a complaint. Right now, is what they're doing is saying that the Secretary of Labor does not need a complaint filed in order to personally move forward and, certify, an H-1B investigation. And this is kind of, important and unprecedented and what you kind of need to look out for, because it is intended to specifically scrutinize employers with, a high H-1B number of H-1B employees. But as a result, it will probably also trigger general audits because there are other workers that are there. And so with interagency collaboration, the Department of Labor, the Department of Justice, Civil Rights, they will all work together. The Equal Employment Opportunity Commission is going to work with them. The Immigration Service is going to work with them. They're all going to be working together. And as a result of, all of this general kind of information sharing between everybody, I would say that it is not improbable to expect an increased amount of audits. Like I said, especially in those areas, where they're H-1B workers, but just, something to keep in mind. Okay, so let's move on to the next slide. Okay. Just general things to keep in mind: maintain the I-9s, maintain your, H-1B compliance folders. If we prepare your H-1Bs, we'll send you the public access files. You must have them easily accessible. Consider reviewing hiring, recruitment practices, sponsorship policies, what you say and don't say in job postings, and just, as a general rule, rules have not changed on this. If you're doing everything the right way and you're in compliant, if you have questions, maybe there's new technology, ask us. But as long as you're doing what you have been doing, there should be no issues for you. So just kind of want you to kind of, have that reassurance in the back of your head, because there's a lot of things in media these days. So we want to just make sure we know, we're dotting our I's and crossing our T's. Okay, Kathy, next slide, please. Okay. This is just an I-9 review kind of, and things to, be aware of and what I've seen in audits. Do your internal I-9 audits. You have time to fix things. And the most important thing is that they're checking when they issue audits is, did you knowingly employ unauthorized workers? If we can show documentation, notation, if there's HR turnover, make documentation, note the dates, explain the situations. If something slips through the crack, which is possible, we are human, we need to make note of that, and then we can see that the person was proactive, that the company was proactively making an effort to not do this, and that will mitigate a lot of the potential fines that you could receive, or potentially even get rid of them altogether. Re-verification also could be necessary, and I'm throwing this in there as well because given recent changes in certain policies like TPS, it's important for HR to also understand that when you bring someone on, they give you the EAD card, the employment authorization document with, a period, of, when it expires and when it starts. Because of this new, policy that has come up, a lot of those dates are now truncated. You may not be aware of it. The employee may not tell you. You may not receive an E-Verify notification. But just know that it is possible. And if you have questions, reach out. There's a lot, it's case by case, but definitely reach out. Let me know. And we can kind of discuss. I'm wrapping up, promise. 1 second. Well, 5 seconds. Can we go to the next slide, please, Kathy? This one, we can kind of, honestly, we can just get this. E-Verify is up and running. Anything that during the week that it was down because of the government shutdown, if anything was done via paper, which it should have been, just go back into E-Verify, put it in. It's okay. There's a drop-down menu where you can put in that there was a government shutdown. Things are above your control. So even if it's past the 3 days, non-issue. If you have questions, please reach out. And then very last slide, just wanted to throw this out there. This only just came out yesterday. So I just wanted to throw this out there, make you aware. In the past, no biometrics when you leave a country. Now they're going to start taking photos. In reality, it's really how is this going to be practically impacted? It's going to take a few years, but they're going to start taking pictures of individuals leaving the U.S. from different ports of entries that in the past were not necessarily considered valid ports of entry. Children under the age of 14 will be thrown into the mix, which in the past they were exempt from it, as well as individuals over the age of 79. There's a lot more information on all of this. Please feel free to reach out if there's any other questions. I will give this back to you, Gabe. I am so sorry I rushed through this. It's a lot of information up there. I'll be back, I'm sure.
Liz, thank you very much. And please do not worry because, as you point out, there is a ton of information. This is a constantly shifting environment. And to the audience, know, as is always the case, Liz's slides will be available and Liz is available. Let's shift to our final speaker for today's program, who is Connor Ingerson. And Connor is new to the webinar. Connor is an attorney who practices primarily in the property space, and I thought it would be helpful for Connor to assess the implications of a package of bills that the governor signed earlier in the program. I was alluding to the fact that, yes, there are vetoes happening with some volume. There are also bill signings that are happening that the governor is getting behind. So, Connor, what can you tell us about this? And as well, thank you for coming onto the program to walk us all through.
Yeah, thanks, Gabe. Thank you for that introduction. And it's a pleasure to be here with all of you for the first time on the webinar this afternoon. And like Gabe said, there's been a flurry of activity, honestly, with Governor Hochul signing all these bills into law that I will dive into. So Kathy, next slide, please. Yeah, on October 16, 2025, so about 2 weeks ago, Governor Hochul signed a comprehensive housing package, which in effect is 2 sub-packages, which I've broken down below, designed to make home ownership more attainable and strengthen renter protection in New York. And this package is part of our overall 5-year affordable housing plan to create and preserve 100,000 homes within the state. So the 2 different sub-packages I've broken down are what I refer to as the homeowners package and the renters package. Now, the homeowner package is designed to make home ownership more attainable through tax incentives and strengthens laws and policies to combat discrimination. And the renters package is designed to further strengthen tenant protections statewide. And these packages affect both the public and the private sector, as I'll get into later on when I touch on the implications of all these different bills that were signed. And as you'll see, some of these changes are more substantial than others. Some of these bills create new laws. A lot of them amend previous laws that are already on the books, and some provide some small tweaks here and there. But I'll be sure to point out which ones really are the ones you should be aware of as we move forward. Kathy, next slide, please. So the first bill that we'll talk about, given the newness of all this legislation out there, they don't have flashy new names yet, so I'm just going to refer to them by their bill numbers. If everyone will bear with me while I get through all of these. So the first is Assembly Bill A355-C. And what this does, it creates an affordable home buyer opt-in property tax incentive for homes built with assistance from either local government entities or state entities, nonprofits, land banks, community land trusts, etc., and are sold to low and moderate income home buyers. So examples of these kind of things can range from government subsidies, grants, to nonprofits such as Habitat for Humanity, or if you're talking about, say, locally here in Syracuse, we have what's called the Greater Syracuse Land Bank that's been buying up properties in order to redevelop them. And this exemption ranges from 25% to 75% of the assessed value of the property. And it's only for residential properties only. And it's important to note the ways that you can potentially lose this exemption, and which would be if the property is not used for residential purposes, or it's not used as a primary residence, or if it's transferred to another person or entity other than to the heirs or distributees of the owner that initially met that qualified low-income household at the time of the initial property transfer from any of those entities that I highlighted previously. And so what is a qualified low-income household? It's simply a household with an income upon initial occupancy of not more than 80% of the area median income. And that will obviously change depending on the location within New York State. Next slide, please, Kathy. The next piece of legislation is Assembly Bill A6770, and this comes on the heels really, and it's designed to address the housing shortage and to try and get as many housing units back online throughout the state as possible, specifically because many municipalities struggle with vacant and abandoned buildings throughout the state. I have many municipal clients that have come to us asking about how we can effectively address these properties. And oftentimes it's because there's a lack of local economic conditions necessary to incentivize this development. And that's what this bill is really targeted to address. And that's honestly due to the fact that the investment required to redevelop these properties can often exceed their value, and the funding gap prevents rather the rehabilitation of those properties. So this, similar to the other bill I discussed, this creates an opt-in tax incentive to encourage redevelopment of vacant or abandoned 1 to 4 family unit dwellings for use as affordable homeownership or rental housing. And this expands on the residential redevelopment inhibited property exemption, which was previously only available to small cities, to the rest of the state and for other types of municipalities to take advantage of. Specifically, the incentive exempts any designated redevelopment inhibited property from taxation or any ad valorem levies to the extent of any increase in the assessment value as a result that can be attributable to any demolition, alteration, or rehabilitation that goes on. So a redevelopment inhibited property is simply if a municipality has acquired title to the property pursuant to an Article 19A proceeding under the Real Property Actions and Proceedings Law, which vests titles in the municipalities to abandoned properties, or if the property has been continuously vacant for 3 years, if the municipality has acquired title via tax foreclosure, or if it has outzoning code violations as well. And similarly, the exemption will discontinue if it's not occupied as a primary residence, or an affidavit that a property owner must annually file is not annually filed, or if it ceases to be a 1 to 4 unit dwelling, or if there are outstanding code violations as well. Next slide, please, Kathy. So legislation A6869 strengthens existing laws and policies to combat home appraisal discrimination. And what this does, it makes it a violation of the state human rights law to discriminate in providing real estate appraisals or in making those services available. So this is familiar to the familiar categories such as race, creed, color, national origin, things of that nature. Or it also extends it to source of income, familial status, or victims of domestic violence as well. And what it does, it enables the Department of State to fine home appraisers a maximum of $2,000 for violations, with half of that money being collected and going to an anti-discrimination and housing fund. And other potential penalties include license suspension or revocation. And although all the appraisers accused of such discrimination are entitled to notice and an opportunity to be heard before the Department of State, and although that appraisers may not base any appraisals on those prohibitive factors, they may take any other factors into consideration that they deem pertinent. Next slide, Kathy, please. And lastly, legislation A3470 closes a loophole in which notifying notice was required to be given before the commencement of a foreclosure action by a homeowners association or condominium board for any unpaid common charges, assessments, fines, or fees. And it specifies that the notice must include both the property address and the specific amount due to the given board. Next slide, Kathy, please. And now we'll move into the renters package, and probably the most substantial piece of legislation to come out of this package, like seemingly most everything these days, has to do with artificial intelligence. Just to kind of orient ourselves here, this legislation comes on the heels of increased scrutiny for prop tech companies such as RealPage and Yardi. This even includes a federal antitrust lawsuit currently ongoing against RealPage. And RealPage, the suit alleges that RealPage's algorithm that they employ unfairly drove rent increases across major markets throughout the country. And a lot of these property management companies will utilize algorithms or artificial intelligence software in order to manage their portfolio of properties. So what this bill does, it makes it illegal for any person or entity to facilitate non-compete agreements between 2 or more residential property owners utilizing any of these softwares or artificial intelligence on behalf of those parties with respect to residential rental units. And it also makes it illegal for any residential property owner or manager, based on recommendations, utilizing these softwares to set or adjust any rental prices or other lease terms and conditions. So essentially what this boils down to, it bans the use of algorithm-enabled software as a workaround by landlords and property managers to arbitrarily set and inflate rental rates, along with other lease terms and conditions, such as renewal terms or occupancy levels. I also laid out, I won't read to you the definition of coordinated function for these softwares, and the majority of them would fall under this definition. And its broad language of price fixing software could potentially include a much wider range of AI-powered business tools as well. The new legislation includes both civil and potentially criminal penalties, but its enforcement mechanisms remain unclear. And it's really remarkable because it's one of the first statewide bans of its kind in the country. California enacted a similar ban that will take effect on January 1st. It also follows several bans across the country in cities such as Jersey City, San Francisco, and Philadelphia. Next slide, please, Kathy. Our next bill in the renters package is A6423-A, and this updates the general obligations law to extend protections given to market rate tenants or security deposits previously under the Housing Stability and Tenant Protection Act of 2019 to rent stabilized tenants. So this will be particularly important if for New York City residents, as they're often rent-controlled situations in the city. Some of these protections include that security deposits may not exceed 1 month's rent, return of security deposits within 14 days given, along with an itemized list of any deductions. And it allows a grantee or an assignee of a rental unit to demand an escrow account be opened on someone's behalf. And it's important to note that any agreement that's found to violate this section, but through a tenant waiving any of their rights, will be absolutely void. And any violators are subject to actual damages and may be subject to punitive damages of up to double the amount of the initial security deposit. Next slide, please, Kathy. So the next piece of legislation is A56-B, and this applies to both market rate and rent stabilized tenants. And this limits the fees that a landlord can collect from a bounced check to the greater of either $20, which is set by statute, or the costs incurred by the landlord. But if the landlord is trying to recoup its incurred costs, it must provide evidence to the tenant substantiating those costs incurred. Next slide, please, Kathy. And I'll briefly touch on the last piece of the renters package, A8412-D, and this implements that the New York City Housing Authority will continue to include policies and procedures allowing individuals to claim succession rights to New York City Housing Authority owned or operated housing units upon the permanent departure or death of the tenant of record. Next slide, please, Kathy. And briefly, the timing on these, the majority of them, as you can see, will take effect immediately, except for the redevelopment incentive and the rent stabilized security deposit bills. They take place 30 days after signing, and the anti-AI price fixing bill will go into effect 60 days after signing. Next slide, please, Kathy. So the implications for the public and private sectors, for municipality and housing authorities, these new laws may require updates to existing policies and procedures to create opportunities to participate in and take advantage of redevelopment initiatives or public-private partnerships to combat the issues of housing scarcity and blight. And they also may require updates to align with the expanded tenant protections, especially in New York City. Next slide, please. For landlords and property managers, these new regulations concerning the extended deposit protections, rent setting tools, et cetera, underscore the need to review and update lease agreements and rent calculation methods to ensure continued compliance. And the renewed focus on fair housing and anti-discrimination by the state emphasizes the importance of transparent and equitable practices in any transactions in property management. Next slide, please, Kathy. And lastly, for developers and investors, the new tax incentives for affordable housing and projects could unlock new avenues for partnerships, municipalities, and housing authorities. And for individuals, the amalgamation of all these different initiative and new bills, including pro-renter updates and anti-discrimination measures, provide greater protection to tenants and those seeking to enter the housing market for the first time. I want to thank you all for your attention. And with that, I will turn it back over to Gabe.
Connor, thank you. You ran through a significant amount of information and appreciate you taking the time to digest it in a way that made it approachable for the audience. As was the case with Liz's slides, Connor's will also be available. Connor, please come on back to the program anytime you have information to share. As you see here, thank you, Kathy. You have the contact information for all of us. We apologize for going a few minutes over today. I will be back with you on the 11th of November. Before that, you'll be with Carrie on Election Day, November 4th. And of course, know that we'll have plenty to tell you about with regard to what happens on Election Day and the implications thereafter. It's always an honor to be with you and looking forward to checking back with all of you in mid-November. In the meanwhile, please enjoy the balance of October, and we thank you for taking the time to tune in today.